Hello guys, and welcome to another episode of Dieko Talks Law. My name is Olayeni Diekolola Daniels, and on today's episode we are going to be talking about the topic, what is a contract. If this is your first time of coming to my channel, kindly click the subscribe button and make sure that you subscribe to my channel, as well as like and also click the notification bell, so that if I release any other video of this nature, you'll be one of the first set of people to get notified about it. So yes, we are talking about contracts today, and this is for anybody who is just getting to know contract for the first time. So yes, you have never sat in a contract law class, or whether or not you sat in one, you didn't understand what the lecturer is saying and you need an extra help. So yes, this class is basically for you and you should enjoy it. So my methodology of teaching basically is that I will literally read out my notes so that you can get a grasp of what I'm going to explain. So I read out my note first and then I explain later. Do you understand? So let us start with the notes. So yes, what is a contract? A contract is defined as an agreement which the law will enforce or recognize as affecting the legal rights and duties of parties. A contract can be defined as a promise or set of promises which the law will enforce. Thus, as we would see in subsequent lecture videos, not all agreement will be enforceable by law. For example, social and domestic agreements are generally not binding in law. Also, the court will not, except in special circumstances, enforce an agreement unless it is supported by consideration. I would explain that in my later class, but that's just to point it out. Now, in the case of Orient Bank PLC versus BILANTE Limited, I would advise that you read this case of Orient Bank PLC if possible. Read the full case. The court held in this case that a contract is a legal enforceable document. Nikitobi JCA defined a contract as an agreement between two or more parties which creates reciprocal legal obligation to do or not to do a thing. For a contract to be valid, there must be mutuality of purpose and intention. Also, in the case of NWLR versus OKOYE 2017 case, the court in that case defined contract to be an agreement between two or more parties creating obligations that are enforceable or otherwise recognizable at law. Now, it is worthy of note that from the above, it can be seen that the common theme underlying all attempts to define a contract in both cases is that there must be an agreement. Both in the case of Orient Bank and BILANTE and in the case of NWLR versus OKOYE, you would see that there is something, an agreement. Also, if you read the definition by INT'L, if you read the definition by Chisaya and 5 Foot, if you read the definition by INT'L, you would see that in each of their definition there is one thing, always the fact that there must be an agreement. Now, the idea of contract as being based on agreement was introduced into English legal discussion only in the 19th century. It was also obvious that another justification for the enforcement of contract is said to lie in the moral obligation of a party to perform his promise. Moreover, one element which is common in all the definition of contract, like I said, is the need for a prior agreement between the contracting parties, which give rise to enforceable rights and obligations. Now, the essence of a contract is the meeting of the minds of parties in full and final agreement. There must be, in fact, a consensus ad idem. Consensus ad idem is an agreement of parties to the same thing as a meeting of the mind. It is the coming together of two parties with a common intention. If the terms of agreement are vague and illusory, no binding contract will emerge from it. For there to be a consensus ad idem, a contract must of necessity involve at least the parties to it for it to be realistic, for a person cannot contract with himself. Now, before I continue with the notes, because there's the last point in the note, there is something which is very, very important which we just discussed. For those that are studying contract for the first time and you are like, okay, what exactly is this course? Basically, there are two people. this is what contract is. There are two people and this person has said something, this person has agreed. Bam, there is a contract. Do you understand that? That's like the most fundamental way to understand it. There are two people. One has said I want, the other is saying I can give. Simple. You have a contract. Do you understand that? Now, there is something that I need you to take out of this particular lecture. For there to be a contract, there must be consensus addendum, which means that the both minds of the individual parties must have met. It's not that one person is saying I want a blue iPhone, the other person is saying I can give you a red iPhone. In that particular circumstance, the both parties' mind did not meet. Yes, there's iPhone, but based on the color, their mind did not meet. For there to be a contract on all the terms of the contract without either party varying it, the both of them must have agreed. There must have been an agreement. It is that agreement that would then give the both of them legal obligation to each other. Do you understand? So when you are defining a contract, the first thing that you must show is that, number one, there is an agreement. When you are defining a contract, there must be an agreement. There must be consensus addendum. The second thing is that this consensus addendum was done between two people, because you cannot have a contract with yourself. Neither can you have a contract with more than two people. That's what I'll be discussing in the latter part of this lecture. But for now, what you should understand is you cannot have a contract with yourself. You need at least another person to have a contract with. Do you understand? Now, in your definition of a contract, you have an agreement between two people. Do you understand? And then there must be a reciprocal obligation to do or not to do a thing. Do you understand that? Reciprocal, meaning that this party must have said I want this. This party must have said I want this. Do you understand? There is a reciprocal obligation on both sides to do something. So, for example, if I say I want a blue iPhone, for example, and I go to the market to say I want a blue iPhone, and somebody gives me a blue iPhone, you can see that from here to here, blue iPhone is moving. It means from here to here, something must move. If something is not moving from here to here, then it is not a contract. It is a gratuitous giveaway. That's what they call giveaway on Instagram. What people do. Do you understand? So, this one is giveaway. That person is doing whatever it is. For example, you guys understand what Davido did when Davido said, oh, give me money and stuff like that. Now, in that case, was it a contract where they gave him money? No, because the money was only coming from here like this. It wasn't going this way. Do you understand? So therefore, there was no contract. But if Davido had said, oh, give me money and then I will give you, now we are entering an agreement where there is money coming from here and something coming from here. Do you understand? So when there is an agreement, not all agreements are contracts. Why? Because not all agreements would give you a reciprocal legal obligation. For example, we can agree that I'll be giving you money for food or whatever it is. You know, like I'll be dashing you 10k per month. That's an agreement. Yes. But then, is it a contract? No. Because except as a term of the contract, you are supposed to give me something. That means there's supposed to be a reciprocal legal obligation coming from you to me. Then, if that is missing in the whole equation, that is merely an agreement. That is not a contract. For you to have a contract, you must have three things being present. Number one, you must have an agreement. Number two, it must be with another person. You cannot contract with yourself. And number three, there must be a reciprocal legal obligation. Where these three things are present, then there is likelihood to be a contract. Do you understand that? Now let's continue with my notes. Now it should be noted that strictly speaking, there can be no contract between more than two parties at the same time. Where it appears that there has been more than two people involved, what it means is that either groups of parties belong to one side or there is more than one contract involved. For example, in a contract of guarantee, usually involving about three parties and two contracts, I then outline the parties and the contract for you. So you have parties, guarantor, debtor, and lender, and number two, you have the contract. Here we have the contract of guarantee between the lender and the guarantor, and the loan contract between the lender and the debtor. Do you understand that? Now, basically, what we are saying is this: you cannot have a contract with more than one person. You cannot have a contract with about three people. No, it is you on one side, then 2 to 3 people on the other side. Do you understand? So this is it. You here, then about 5 people here. Do you understand? Or 3 here, 2 here, or something. But when it comes to a contract, because they are saying the meeting of the mind, you cannot have 3 people's mind meeting in a circle. No, you have to have just 1 here, 1 here. There cannot be like several parties here and several parties here. Or you can have different contracts. For example, when you are talking about the contract of guarantee, Mr. A is promising to give Mr. B 5 million naira, 10% interest per month. But in a contract of guarantee, you need a guarantor that will be able to pay. He has the financial ability to pay that money in the event that Mr. B does not pay the money. You get? Now, that's Mr. C. Now, in that case, we have both Mr. A. A is the lender, B is the debtor, C is the guarantor. Do you understand? Now, you are not signing one contract there. No. You are signing 2 contracts. The first contract is between the lender and the debtor. And what is the contract? The loan agreement. The second contract is between the lender and the guarantor. That is the guarantee agreement. Do you understand? So in a contract, typically speaking, strictly speaking, you cannot have more than 2 parties in a contract. In one particular contract, you cannot have more than 2 parties. But where something seems very clustered, that you are seeing like about 3-4 parties, then there are 2 possibilities. The first possibility is that when you are regarding that particular contract, there are about 2 to 3 people in one party. It is one party, but 2 to 3 people. Do you understand? Or there are more than one contract. Do you understand that? So with this, I'm going to give you an assignment, and I would like you to comment in the comment section below answering this particular question that I will be posing to you. It's just to help you with your ability to answer questions when you see them and stuff like that. So let's go straight to that particular question. A renowned judge once said, if there is one thing which more than another public policy requires, it is that men of full age and competent understanding shall have the utmost liberty of contracting, and that contract, when entered into freely and voluntarily, shall be held sacred and shall be enforced by courts of justices, as stated by the judge, Sir George Jesel M.R. So basically, the essence of the assignment is you should go and look in your own personal time. Go and look up the reason for the enforcement of a contract. There is a moral obligation to enforce contract. Why exactly do we need the moral obligation? Because except the law tries to enforce contracts, people are going to make promises anyhow. For example, your father or your uncle or your this that said that if you graduate from university with a first class, I'm going to buy you a car. That is an agreement. That is a contract. Why is it a contract? Because there is a promise that if you should do something, I will buy you this, which means that there is a legal obligation going from your part, and that legal obligation is for you to get a first class. If you're able to get a first class, then your uncle or your dad that promised you the car, or your mom that promised you the car, must, because that's a contract. Do you understand that? So there has to be a moral obligation enforced by the courts to make sure that parties to a contract, honor their contract. Because in the absence of that enforcement by the court, then people will make promises just for the sake of making promises, especially when the other party has relied on their promise. Do you understand? So I want you to look up other reasons why the court should enforce contracts. Also look more on this moral reason for the enforcement of contract. Make sure that you type it in the comment section below, and I will see you in my next class. Thank you so much.